Good morning, everyone. Joining through Zoom as well as from Facebook Live. Today, this is the 25th webinar of Nepal Council of Arbitration, NEPCA. And Ms. Eunice Kong from Malaysia has agreed to make presentation for us. So first of all, I would like to welcome her in this our NEPCA platform. And for our presentation. Topics for today is construction dispute resolution in Malaysia, legal framework and practical insights. Says by profession, she is an advocate. She has obtained LLB honors from University of London in 2016 and subsequently a certificate for legal practice in 2017. She is a proficient commercial litigator, commercial litigation. She's working in the field of commercial litigation, particularly including shareholder and company-related disputes and other construction-related disputes also. She is associated with partner Ricky Tan and Company as International Business Development Director of the China Asian Legal Cooperation Center. I think she was based on Beijing also for some time. And we met at Urumqi, China in an arbitration forum. It was held in April 2025. And while we talked about NEPCA's these activities and webinar, she was so kind that she accepted my invitation to make presentation particularly for our Nepali audience about the experience from Malaysian construction industry. Most of the time that we discuss about, we take reference about Malaysian construction industry in Nepal. So by this, I welcome again Eunice for your presentation, and you will have 45 to 60 minutes, 1 hour presentation, direct presentation, and then we'll go for discussion, and by 10:30 Nepal Standard Time, we'll conclude this presentation. So now floor is yours, Eunice.
Thank you. Good morning, everyone. I'm Eunice, and first of all, I would like to thank Mr. Rajendra for the kind introduction and also his invitation for me to join this session today. It's really a pleasure to be here today, and I would also like to extend my appreciation to all of you for taking the time to join me on this Saturday morning. And I know that weekends are precious, and I really value your presence here together with me today. So I hope these sessions will be fruitful for all of you, and I will do my best to share both practical and also my experiences in the construction industry in Malaysia. So with that, I will begin. So first of all, let me share my screen first. Okay, the topic that I'm going to share today is about construction dispute resolution in Malaysia, the legal framework and practical insights. The construction industry plays a crucial role in Malaysia's economic development, contributing significantly to job creation, infrastructure development, and overall social progress. For today's presentation, I will divide it into 4 broad topics. First of all, we start with overview of construction industry in Malaysia, and then will be standard forms of construction contract applicable in Malaysia, common causes of construction dispute, and lastly will be dispute resolution mechanism. Okay. In Malaysia, the construction industry is regulated by the Construction Industry Development Board Malaysia, which we call it CIDB, under the CIDB Act 1994. So this CIDB Act imposes the regulation on building-related activity. Okay. If we refer to Section 25 of CIDB Act, which says that no person shall carry out or undertake to carry out or complete any construction work or hold himself out as a contractor unless he is registered with the Lembaga, which is the CIDB board, and holds a valid certificate of registration issued by the board under this act. So in other words, all the legal entities who wish to carry out construction work in Malaysia, they have to apply and register with CIDB. So for local contractors, like Malaysian company, once they have registered, they can carry out construction work under the approved grade limits during the validity period. So the grade limits will depend on how much capital that the Malaysia company has. So on the other hand, for foreign contractor, they are required to apply for registration with CIDB for each project. So for example, if the foreign contractor wishes to undertake 10 projects, then they will have to apply for 10 separate registration certificates for all the projects with CIDB. So basically, how do we differentiate whether it's a local contractor or whether it's a foreign contractor? So for local contractor, by name, it would be Malaysian company held by Malaysian. But for foreign contractor, it can be a company incorporated abroad. Say, for example, Singapore, Thailand, Nepal, or anything. Or it can be a company incorporated in Malaysia, but there are foreign shareholders who hold more than 30% of the share in the company. Now we will go to the key statutory or legislative obligation relevant to construction. So these are the 5 important legislation or act that a contractor have to comply to. The first one is the Town and Country Planning Act 1976. Okay, for construction work is primarily governed under this act, the Town and Country Planning Act, and also Street, Drainage and Building Act, along with other subsidiary legislation. So any project categorized as a development within the Town and Country Planning Act will require prior planning permission from the local planning authority, which we call it development order. So they have to apply for a development order first before a project can start. So generally, the development order will be granted with certain conditions because they have to align with the government planning to the state or to the town. So normally, for a developer to construct a new building, say from commercial building or residential building, there will be certain conditions imposed on them. Say, for example, they have to construct public road, they have to construct highway ramps to enable access from the public. So this legislation provides the minimum standard for the control and also construction of the buildings in Malaysia. And it also set out the procedure regulating application for building plans approval, as well as the requirement for firefighting service. This is compulsory. So next, Occupational Safety and Health Act 1994. This act focuses on the provisions for securing the safety, health, and welfare of the persons working at construction site to protect their risk and also safety and health when working over there. So next will be Factory and Machinery Act Amendment 2006. So these are the act that ensures the fitness of machinery deployed during the course of construction work, and also similarly imposes a positive obligation on the employer or developer to ensure the safety, health, and welfare of the person employed. And lastly, we have the Housing Development, Control and Licensing Act 1966. And this is actually the act that governs residential projects. Under this act, there is a statutory period for a developer to complete a residential project. For example, for a condominium, a high-rise building, the developer will require to complete the the construction and deliver vacant possession within 36 months. And for landed property, the developer will need to complete the construction within 24 months. But if the developer will require for further extension, they can apply for EOT, extension of time, with the Housing Ministry of Malaysia. Okay, now we will talk about pre-construction process. So basically, what the contractor or the developer have to do before we undertake a project, a construction project. Generally, it will start with bidding or tender. For bidding or tender, there are 4 kinds of bidding and tender in Malaysia. First is open tender, whereby the tender will openly advertise to all buildings or contracting firms to lodge a bid. Second, selective tender. So there will be only the selected contracting firms or contractor are invited to submit a tender bid. So normally for this kind of tender, the client, the employer, will issue an expression of interest or registration of interest to the contractor. And because this matter will ensure that only the capable and experienced contractor can participate in this tender to enhance the quality of submission and also reduce the evaluation workload. So for pre-qualified tender, there will be some qualification that the contractor will need to satisfy before they can participate in the tender. So these are usually used for more specific government tender, because under our, in Malaysia, for government projects, only a Malaysian native company will be qualified to participate in the tender, and not the foreign company, because there will not be a Malaysian native inside the company. So for negotiated tender will be direct negotiation between the project owner and the selected contractor. So these are usually suitable for project requiring a high level of expertise, which are not every contractor can do, or where the project owner has a preferred contractor based on the past performance. So after the project owner opened for the bid and the contractor submitted for tender, so the project owner will shortlist the preferred contractor that will evaluate the contractor based on their pricing, quality, experiences, time frame, and also choice of the subcontractor. And after that, they will award the contract to the contractor, and the contractor, they have the option either they can do it themselves, do all the construction work from A to Z themselves, or they can engage subcontractor, or that the developer may have nominated subcontractor. So these are usually the general pre-construction process that will be undergoing before a construction work can jumpstart. Okay, now we will go to the standard forms for construction contract. In Malaysia, it's quite frequent that the project owner or the employer will use some standard forms of construction contract for the contract between the employer and the main con, or the contract between the main contractor with the subcontractor. So these are the 5 standard forms contract that will be usually used in Malaysia construction industry. First is what we call PAM contract. PAM is actually stand for Malaysian Institute of Architects contract. And next will be PWD forms. We will go into details of each of the standard form contract later. So for PWD forms is a public works development. So these PWD forms will usually applicable for government project. FIDIC, I believe that all of you will be familiar with what is FIDIC. So this is usually used for like the project that involve international parties, and also for EPC contract, which is more technical. For IEM is the Institution of Engineering Malaysian form. So this is actually the standard form contract drafted by the Institution of Engineers Malaysia, which is usually used for engineering work. And CIDB is the board that I mentioned, the regulatory board that I mentioned just now, and they have come up with their standard form contract as well. Okay, now PWD, Public Work Department forms, as I explained just now, is common in government project, and there are different type of standard form contract. We call it PW203. PW203 is actually the contract based on drawings and specification. PWD203A is actually the contract where the bills of quantities form part of the contract. And PWD-DB stand for the contract for design and build. So inside this standard form contract for PWD form that provides details clauses on time, payment, variation, and also liquidated ascertained damages, LAD, in the event that there's a delay in completion of the work. So for CIDB standard form is issued by the CIDB Board Malaysia, and is actually cover both conventional and design and build contracts. So this contract is more on a balanced risk allocation and compliance for the employer and the contractor. So next will be PAM. PAM contract is the most widely used contract, especially in the private sector building work. So there are two versions for PAM contract, which is PAM 2006 with quantities or without quantities, or PAM 2018 with quantities or without quantities. So the specialty of PAM contract is that the architect will play a central role in the contract administration. So basically, everything like for variation, for a certificate of payment, they will need to get the approval or certification from the architect. So architect will play an important role in this contract. So for IEM form, these are usually used for engineering and infrastructure projects. So it's suitable for projects when the engineer will play a central role. And lastly will be FIDIC, which are popular for international infrastructure projects that have red books for construction, yellow book for plan and design build, silver book for EPC or turnkey contract. So we often use standard forms like I say just now, PAM or FIDIC or PWD because we want to reduce conflict. But issues persist due to the misinterpretation and also unclear drafting of this standard form. So there are common causes of construction dispute which arises from ambiguous clauses, poor documentation and record keeping at the site and also the contractor office, unclear payment terms, inadequate time extension and delay, and also delay in raising dispute. So construction disputes in Malaysia are often rooted in flaws or ambiguities of the conditions contract. So what are the common causes of construction dispute in Malaysia? So there is a survey carried out previously, and it was find out that 87% of the dispute in our government project standard form contract relate to delay and extension of time clause. While on the other hand, 78% of the dispute in PAM 2006 is related to certificate and payment clause. So most of the issue are related to time and also money clauses, which are the heart of construction delivery. So these are the few clauses in PAM contract that will normally give rise to dispute. Is mainly because the contractor did not receive the money, or that there's under certification, or that the contractor work has been delayed and have applied for extension of time but has been rejected, and so on. We will come to this in details later. So, as I say just now, payment is an issue that happened in Malaysian construction industry, because there is a delay in payment or no payment for the completed work that will cause the contractor to have no fund to continue with the construction work, and lastly will result in abandoned project. So sometimes there will be a disagreement over the valuation of work done or certification, or because that the main contractor or the employer suffer from cash flow disruption, impacting the contractor and subcontractor receiving payment. Delays will be the issue that will normally arises in Malaysia due to many factors. There might be dispute over whether delays are justifiable in granting the extension of time, and also the LAD claims. For variation order, this is where often that will give rise to dispute, because sometimes the employer representative will instruct the contractor to carry out variation work. However, there's no written instruction given. So when the contractor completed the work and they submitted their claim for the VO, the employer rejected the claim, saying that this is covered under your scope of the work. So the dispute arise over cost, the timeline impact, and also the approval process. And also, there is a lack of clear documentation and also proper contract procedure, because normally for small project or for urgent work, the employer representative will just give instruction on site. So this is where the problem arises, when there's no written instruction from the employer to instruct the contractor to carry out the work. And there's also another issue about LAD. So in Malaysia, generally, we don't set a limit to the LAD. The LAD imposes might exceed the contract sum, which will be really unfair for the contractor. But this is the problem. And also in Malaysia, we are a common law jurisdiction, so we follow case law. So recently, we have a case law delivered by the highest court in Malaysia, Federal Court, which states that the contractor do not need to prove the actual losses for due to the delay suffered. So in other words, if the main contractor impose a LAD, a liquidated ascertained damages, on the subcontractor, it is not a condition for the main contractor to prove that the employer has imposed the same liquidated damages to the main contractor. They don't have to prove that. As long as there is a LAD clause in Malaysia, in the contract, the main contractor can impose the LAD on the subcontractor. So this is the problem. Next, the issue, like after we have the contractor has completed the work, there is defect within the DLP, the defect liability period, in respect of to the quality issue or non-compliance with the specification. So normally, the disputes arises will be on what constitute a defective work. Is it must be related to the workmanship of the contractor, or it can be anything, including wear and tear of the products. So, so this is normally where we find the dispute lies. And lastly, will be the termination of contract. When the employer fail to make payment to the contractor, can the contractor terminate the contract or suspend its work? So the dispute will arise over whether the termination was valid or wrongful. And in the event that the termination is wrongful, it will lead to the claims for compensation, loss of profit, and also the demobilization costs. And also there are also others problems like loss and expenses. There is loss and expenses suffered by the contractor, but because of lack of supporting evidence or the procedural misstep for the contractor to claim for this loss and expenses, and this claim has been barred. Okay, and also I would say that most of the disputes are actually arise due to the lack of clarity in contracts, the ambiguous clause, a missing provision, and also the poor documentation, missing record or no written approval or instruction, and inadequate communication, poor coordination among stakeholders. So I find it these are the major problems encountered by the contractor, especially the foreign contractor, because they are not familiar with the culture, the industry in Malaysia. So these are the disadvantages that the foreign contractor will suffer. So it's very important for them to make sure that there is a proper documentation. Every communication must be in writing, and that they must understand what is stated in the contract. So are there any limitation periods for commencing dispute in Malaysia? So when there is dispute arise, what can the contractor do? Can the contractor sit and wait? The answer is no, because under our Malaysia Limitation Act 1953, Section 6, Sub 1, there is a limitation period of 6 years from the date of which the cause of action accrue. So it will have 6 years. We'll have 6 years time to sue or to resolve this dispute. If after 6 years, this dispute has not been resolved and the contractor only wanted to start to sue, I'm sorry, it's too late. The court or the arbitration or any form of the dispute mechanism will not accept your claim. So this is the limitation period in Malaysia, 6 years. So what about latent defects? The defects that is not apparent, that is not obvious, and is only discovered outside the limitation period. So according to our Section 6, Capital A of the Limitation Act, the parties will have 3 years from the date of knowledge of such defect to commence a claim. So, but however, there is still an overall limitation of maximum time bar of 15 years from the date of the occurrence of such defect. So, for example, there is a crack over a pipe, and it might not be apparent, and the developer has only discovered it after 6 years. So after the developer discovered it, they inform the contractor and say, hey, there is a problem to your work. There is a crack over the house, so you have to rectify. And the contractor refused to rectify. Despite after the 6 years, the developer can still start this claim in the court because they have only recently discovered this defect. So even though it might be proven by the expert that actually this crack has been there since 6 years ago, but never mind, the developer will have 3 years after he become aware of the defect to claim. So the developer have to quickly prepare his case in court or arbitration. And this is the law applicable in Malaysia. So when there is dispute, it's very important to know what are the dispute resolution mechanisms. So these are the 5 dispute resolution mechanisms that are commonly used in Malaysia. So in Malaysia, we actually offer a structure and evolving legal framework for resolving construction dispute. We have mediation, negotiation, adjudication, arbitration, or court litigation. So I will go through this one by one. So mediation. So mediation is a process that involves a neutral third party that does not make a decision for the disputing party, but to facilitate and find a solution for the disputing parties. So the advantages of mediation is that it's flexible, it is informal, fast and cost-effective, confidential, and non-adversarial, which helps to promote amicable settlement and preserve business relationship between the parties. So although there will be a mediator, but the role of the mediator is to facilitate the parties to find out what is their differences and what is their common ground in order to try to, for the parties to explore a solution to move the parties to a win-win situation, win-win outcome. So when goodwill exists between the parties, mediation being a non-adversarial procedure will help, because we often see that it's not unusual to see the parties coming out from a successful mediation, shaking hands with each other, and with a promise of more business dealing in future. But we, however, never come across any parties coming out from the courtroom after a trial, shaking hands with each other, or with a promise that there will be more business collaboration opportunity in future. So mediation is actually a good way when the disputing parties still want to preserve a good relationship between them. So in Malaysia, mediation is governed by our Mediation Act 2012, which is enacted to promote and encourage mediation as a method of alternative dispute resolution, ADR. But mediation is not compulsory in Malaysia, so it's subject to the parties' agreement. Only when both parties agree, then this case can be referred to mediation. But if either one of the parties disagree, I'm sorry, mediation is not possible. Okay, but under our Mediation Act, there are some disputes that cannot be mediated. For example, prerogative writ, injunction, judicial review, appeals, or any proceedings before a native court, any criminal matters. So these are the the matters that cannot refer to mediation. So in mediation, for mediation in Malaysia, we actually have a few mediation institutions, like our Malaysian Mediation Center. We have AIAC Mediation Center. We have also Court Mediation Center, CIDB Mediation Center, and others. So for mediation, the decision is made by the parties and will be recorded in the settlement agreement. So if one party does not comply with the settlement agreement, the non-default party can only sue the defaulting party for breach of settlement agreement. So there will still need to bring this matter to the court in the event that the settlement agreement Okay, next will be negotiations. So negotiation will not involve any third party, and it is a process for both disputing parties to discuss, negotiate, to reach an agreement that is acceptable to all parties. It's simple, flexible, confidential, quick, and informal. So this is the preferred route in most for most commercial people. So negotiation might not be very effective, because I believe that most of the time when there is dispute, the parties will try to negotiate and discuss. But only when the negotiation is not possible, they will need to resort to the alternative dispute resolution. And also, we have court litigation. So this is a very common dispute resolution mechanism in Malaysia, whereby court litigation is a legal process where disputes are resolved in a formal court sitting before a judge. So because Malaysia is a common law jurisdiction, so it will involve presentation of evidence, examination in chief, cross-examination, and re-examination. So the lawyers or the parties will have to follow strict procedural rules, because there will be a judge, an independent party sitting at the court, so it will ensure fairness, legal accountability, and also public record of proceeding. So the advantage of litigation is that it's legally binding and enforceable. It follows a clear and standardized procedure. So there is a possibility to appeal if one party is not satisfied with the outcome. And also the benefit is that it can establish a legal precedent for future cases. So this is the Malaysian court hierarchy structure. So for the lowest court, we have magistrate court. Next will be sessions court, high court, court of appeal, and federal court, which is the highest court in Malaysia. So for the courts that has originating jurisdiction, which means that you can bring the legal case at this court, will be magistrate court, sessions court, and high court. So how do we differentiate on when should we bring our matter in magistrate court or sessions court or high court? So we will differentiate this by the monetary jurisdiction. So for magistrate court, the magistrate will have the monetary jurisdiction to try the dispute that is 100,000 Malaysian ringgit and below. For sessions court, the sessions court judge will have the monetary jurisdiction to try the dispute between 100,000 to 1 million Malaysian ringgit, and for high court will be 1 million and above. So these are the courts that have originating jurisdictions. So for court of appeal and federal court, they only have appellate jurisdiction, which means that they will only hear the appeal or review a decision by the lower court. Okay, so in Malaysian court system, we have a two-tier appeal process, which means that you can appeal twice, 2 times. So for example, if the matter arises from the high court, the originating jurisdiction is from the high court, you can appeal to court of appeal, and if you are dissatisfied with the court of appeal decision, you can appeal to federal court, and federal court decision is final. So there's 2-tier appeal process. You can appeal for 2 times. So what about if a case is started from magistrate court? Similarly, you can appeal to 2 times, but the appeal will not straight away jump to the court of appeal. No. The appeal will start referring to sessions court. This is the first tier. And second tier will be high court. And high court decision will be final. So if the matter start from magistrate court, the highest jurisdiction will be high court. Your matter cannot be referred to federal court. And because we have only very less federal court in Malaysia, therefore the requirement for a matter to be referred to appeal to federal court is very difficult. First of all, you have to seek leave, the consent from the federal court first, before you can appeal to the federal court. Once the consent is granted, then only the federal court will hear your case. And similarly, not every cases will be referred as an appeal to court of appeal. There is a minimum threshold of 250,000 Malaysian ringgit. So for example, if your matter is only 100,000 Malaysian ringgit, it does not mean that you cannot appeal. You still can appeal, but you have to apply for a consent, a leave from the court of appeal before they will hear your case. So for the two-tier appeal system, it ensures efficiency and it also ensures finality to a case. So moving on, we will go to a specialized construction court in Malaysia. So in Malaysia, we currently have 3 specialized construction court in Malaysia. We have 2 in Kuala Lumpur, and we have 1 in Shah Alam, Selangor. So these construction courts are all high court. They have the judges assigned to the construction court will have a specialized knowledge of construction law, and this court can hear and dispose of construction dispute and also the application for setting aside an arbitration award, adjudication award, registrating of an arbitration award, and so on. So all the matters relate to the construction dispute, the High Court. So the minimum monetary threshold will be at least 1 million ringgit Malaysia. Okay, in Malaysia, there is also a frequently used dispute resolution, which we call arbitration. So for a matter to be referred to arbitration, there must have an arbitration agreement in the contract. So the benefit of arbitration is that it is final and binding, because in arbitration, there is no appeal. You can only set aside the arbitration award if there is a procedural impropriety. So the benefit of arbitration is that is cost saving, because the parties will not have to incur cost to file the appeal. And in Malaysia, we have two-tier appeal. So the parties will incur, if you are dissatisfied with the court decision, you have to incur cost to appeal twice in the court. So you are not only have to pay the legal fee, but you also have to pay the court fee as well, despite the court fee is not high. And another benefit is that the arbitration decision is enforceable. But in Malaysia, you have to register the arbitration award with the Malaysian court. But generally, the enforcement or the registration process will take around 3 months' time, and also provided that the setting aside application is not tedious. So sometimes it might take for six months times to 1 year's time, but it's rarely that a case will extend for 1 year times. Normally, maximum will be 6 months. And another benefit of arbitration is that you can apply for interim measure with the arbitral tribunal. So the interim measure available in Malaysia is, for example, security for costs, discovery of documents, giving evidence by affidavit, preservation or interim custody or sale of property in order to preserve the asset, which is a subject matter in the dispute. So for a matter which is referred as an arbitration in Malaysia, the benefit is that Malaysia is a signatory to the 1958 Convention, the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. As such, an arbitral award from Malaysia is enforceable in more than 161 countries. So no matter that the parties to the dispute is a foreign disputing parties, even if the matter is referred as arbitration in Malaysia, you don't have to worry because Malaysia is a signatory to New York Convention. The arbitration award delivered can still be enforceable in more than 161 countries. So for arbitration, we have ad hoc arbitration and also institutional arbitration. So for ad hoc arbitration, there will be no institution to administer the arbitration. So parties are free to appoint their own arbitrator and also free to conduct the arbitration however they wish. So it allows flexibility and freedom because there's no institution rule, so there's no standard procedure. So it's subject to the parties' agreement. For the institutional arbitration, so this arbitration will be referred to an arbitration institution, such as in Malaysia, we have AIAC, Asian International Arbitration Center, or you can also even refer your matter to the Singapore International Arbitration Center or our Nepal Arbitration Center as well, or Hong Kong as well. So the arbitration process will be governed by a set of rules that have been drafted and set by these arbitration institutions. So it will save time for the parties when from negotiating the applicable procedural rule and also the appointment of arbitrator. And more often, this institutional arbitration, they will provide a skill fee on the arbitration fee and also cost. So in Malaysia, we have a main arbitration institution in Malaysia, which we call it Asian International Arbitration Center, AIAC, and previously known as Kuala Lumpur Regional Center for arbitration. So this is actually sit in an iconic building in KL, which we call it Bangunan Sulaiman, and this is the building. So while AIAC is the primary institution, but the Malaysian parties are not limited to it because they can still choose the other international arbitration center or opt for a ad hoc arbitration. So according to our AIAC arbitration rules, there are two kind of arbitration rule. First, we call it a conventional AIAC arbitration rule, and another is the AIAC fast-track arbitration rule. So when there is a dispute, you can choose on whether you want to go to the conventional arbitration under AIAC, or you want to go for a fast-track procedure. But there are certain requirements or qualifications that you need to satisfy before you can refer this matter and to go for fast track. And first is that the amount in dispute must be less than $500,000 for an international dispute, while for a domestic dispute, which the dispute arises in Malaysia involving the Malaysian party, the amount in dispute must less than 2 million Malaysian ringgit. And also, you have to prove that there is an exceptional urgency for your matter to be referred to fast-track procedure. So basically, not every cases can refer to fast-track unless the parties agree to refer so, or you can prove that there is exceptional urgency. Okay, if not, I'm sorry to say that your matter can only refer to the convention arbitration. So, but convention arbitrations, it might take around 6 months to 1 year, depending on the complexity of the case and also to the parties' agreement. So for the award time, generally it will be 90 days from the closure of proceeding, which is the closure of hearing. So the arbitrator will need to deliver the arbitration award within 90 days. But for fast track, it will be much faster because the fast track rule mandates that the award to be made within 6 months from the date of constitution of the arbitral tribunal, unless otherwise agreed by parties. So in fast track, everything has to be fast, and the timeline must be strictly focused and adhered to. But on the other hand, for a conventional arbitration, parties can take their time as long as they are agreeable to it, and there is no strict timeline for the parties or arbitrator to comply to. So what is the effect of arbitration award? As I mentioned just now, even if you have obtained an arbitration award, you still have to register it in the Malaysian court to become a court judgment. Of course, the parties can still challenge it, but not appeal. But you can only apply to set aside it in a very limited or strict ground. So these are the grounds that you can actually set aside or refuse for the court to refuse to recognize. First is when the parties who enter into the arbitration agreement was under incapacity, or when the arbitration agreement is invalid, or when that involve a procedural impropriety, say, for example, lack of proper notice or inability to present case, because this will deprive the parties of a fair opportunity to let their case to be heard. So when the awards deal with matters outside terms of conference, out of jurisdiction, I would say, or the award exceeds the scope of submission to arbitration, improper composition of tribunal or procedural, dispute not arbitrable under Malaysia, for example, when it involves domestic divorce, family dispute, these are not the matter that can refer to arbitration, or when the award is contrary to the Malaysian policy. So we will go for it one by one. So this one I have actually mentioned it just now. So I will go through with you on the case law. Okay. This is our Court of Appeal decision, and what happened here is that the arbitral award was delivered late under the Article 21 of PAN arbitration rules. So is this a ground to set aside the arbitration award? The answer is yes. The Court of Appeal held that the timeline is mandatory and not really a mere procedural formality. So the court held that the arbitrator's failure to comply with the time limit has exceeded their jurisdiction and thereby render invalid and unenforceable arbitration award. So the arbitrator has to be careful on the arbitration rules and have to comply with a mandatory rules set by the arbitration rules. So because sometimes the arbitration award might be challenged due to some very technical ground, like the example, like the case law that I showed it to you just now. So sometimes it might be good for the parties to consider court litigation, despite in our court system, we have two-tier appeal. But in some of the cases, the parties can apply for summary judgment, which means that this matter do not have to go for full trial. The parties can request the court to hear this matter summarily based on the document. So for simple matters, straightforward matters, sometimes it might be beneficial for the parties to refer to the court instead, provided that there is no arbitration agreement. Okay, so there is also an interesting case that I want to share to you all, which is the Court of Appeal decision in Kebambangan Petroleum against Mikuni. So what happened here is that there is an arbitration agreement, and the non-default party referred this matter to arbitration. But the defaulting party, the respondent, he refused to pay the arbitration fee or the deposit. So what happened here is that the non-defaulting party or the claimant, so they proceeded with court litigation despite there is the arbitration agreement. So the respondent, he filed an application to stay or strike out the court proceeding. So in this case, the Court of Appeal held that the participation in court proceeding signal willingness to litigate, thereby defeat the arbitration agreement. And also, coupled with the fact that the respondent refused to pay the deposit, which will render the arbitration agreement inoperative. And therefore, the court held that the claimant can refer this matter to the Court of Appeal due to the respondent conduct in making the arbitration agreement inoperative. So there's also one interesting dispute resolution mechanism that I want to share with you all, which call it adjudication. It involves the written submission of dispute to a neutral third party. So in Malaysia, arbitration, we have two types of arbitration: adjudication. Statutory adjudication under our Construction Industry Payment and Adjudication Act, and also contractual adjudication if that is provided in the agreement, in the contract. So for contractual adjudication, it's a consensual process. But for statutory adjudication, despite this is not covered by the contract, but you can still refer this matter to statutory adjudication because this is your statutory right. So the distinction between statutory adjudication and contractual adjudication is that statutory adjudication can be enforced as a judgment, but for contractual adjudication, it is enforceable as a contract only, not a judgment. So if the losing party fail to perform the contractual adjudication decision, this will constitute as a breach of contract. So you will still need to refer this matter to the court to decide. So in Malaysia, we actually has a long history of payment dispute in construction industry because approximately based on the data, there are 50% of construction projects experience underpayment or late payment or non-payment issues. So this leads to delay in completion of the construction project or altogether abandonment of the project in some cases. So to address such problems, the government of Malaysia, they passed the law in 2012, which we call it Construction Industry Payment and Adjudication Act, introducing a new dispute resolution mechanism for the parties in the construction industry to resolve their dispute. So the objective of this SIPA, we call it SIPA, is to facilitate regular and timely payment, to provide a mechanism for speedy dispute resolution through adjudication, and to provide remedies for the recovery of payment in the industry, and to provide for connected in incidental matters. So in other words, when there is a dispute over payment relating to a construction contract, you can refer this matter to SIPA. We call it SIPA, which is the statutory adjudication. But because this SIPA Act has only been introduced or enacted in 2012, and it actually only came into force in 15th of April 2014. So which means that every construction contract enter before 5th of SIPA. Only the contract enter after 15th of April 2014, you can refer this matter to SIPA. So for this SIPA adjudication, there will be an adjudicator appointed by AIAC which is the adjudication authority under SIPA, the only institution that has the right to appoint adjudicator under the SIPA. So as I mentioned just now, not every cases can be referred to this statutory adjudication SIPA. Only when there is a construction contract made in writing relating to construction work within Malaysia, then you can only refer this matter to SIPA. And this SIPA does not apply to a construction contract enter for any construction work in respect of any building less than 4-story high, or which is wholly intended for his occupation. So in other words, if it's a very small project, less than 4-story high for the building, I'm sorry, you cannot refer this matter to SIPA. So the countries that have similar laws to the SIPA Act, the statutory adjudication, is UK. They have the Scheme for Construction Contract, Inland and Wales Regulation. And New South Wales, Australia, they have the Building and Construction Industry, Security of Payment, New Zealand, and Singapore. So these are the few countries that have this statutory adjudication. So the special characteristic of SIPA is that it allows a party for a prompt payment. There actually has a slogan to say that pay now, argue later, which means that when this matter is referred to SIPA, as long as that the adjudicator finds that there is a payment due, you have to pay now, despite you argue that there is a LAD, there is a setting off by the employer and so on. But sorry, if the evidence is not strong enough, your claim will fail and you have to pay. And then you need to refer this after the adjudication decision is awarded, you can still refer this to court litigation or arbitration. So the decision made by the adjudicator under SIPA is actually temporarily binding unless it is set aside by the High Court, or the matter is settled by both parties, or the dispute is decided by the arbitration or court. But you still need to pay first and argue it later. So actually, this statutory dispute resolution mechanism, it provides for recovery of payment, and also the objective, the aim is to reduce abandoned work due to non-payment. So so there is also one specialty about this SIPA is that the back-to-back clause is void under SIPA. So whenever there is a dispute relating to payment, and say, for example, the dispute between employer and contractor, and the contractor refer this dispute to the SIPA, but the employer say, oh no, I don't have to pay you because I didn't receive my payment from my financial. Okay, so the employer say this payment has not due yet, so I'm not obligated to pay you. But if this matter is referred to SIPA, I'm sorry, this clause is not valid. The adjudicator will not take into account this clause. So more often than not, the adjudicator will say, sorry, no matter what is the condition of payment, you have to pay first. So this is actually governed under Section 35 of the SIPA Act, prohibition of condition contract. So it's actually defined what is the conditional payment provisions. It's when the obligation of one party to make payment is conditional upon that party receiving payment from a third party, or the obligation of one party to make payment is conditional upon the availability of funds or draw down from financing facilities of the parties. So give you an example. Is this clause constitute as a conditional clause? Okay, I will read it out. The contractor shall allow or pay to the employer all costs incurred to complete the work, including all losses and all expenses suffered by the employer until after the completion of the work. The employer shall not be bound by any provision in the contract to make any further payment, including payment which have been certified but not yet paid when the employment of the contractor was determined or terminated. Only when upon completion of the work and account taking into consideration the value of the work carried out by the contractor and all tolls and shall be incorporated in the final account. In other words, this clause says that the employer do not have to pay the contractor first if the contract has been terminated. Only when the final account is completed, then the payment obligation will arise. So what happened in this case, Ecompound Malaysia Sdn Berhad, is that there is such a clause 25.4D in the contract. And the contractor, after the contract has been terminated, brought this claim to SIPA to claim for the outstanding payment. So the employer said, no, because the final account has not been issued yet, I do not need to pay you. So the High Court actually held that upon clause 25.4 has the effect that upon the termination of contract of postponing payment due until the final account are concluded and the work completed, this clause is actually defeat the purpose of SIPA and therefore void and unenforceable. Okay, how about pay if certified clause? For example, this clause, I will only pay you when there is a certification by the Ministry of the Transport. Okay, so in this case, the Court of Appeal held that in Lion Pacific Sdn Berhad again Pastec, the court held that actually pay if certified cannot be construed as a conditional payment because there is a mutual agreement of the parties that the appellant obligation to make payment will only arise upon certification of work done by the Ministry of Transport. So in other words, it's not a conditional payment because the appellant is not waiting for payment from one party. The appellant is only waiting for certification. Because there is no certification by the authority agreed by the parties, so I do not have to pay. And the court agreed that this is not a conditional payment clause under the Section 36 of the SIPA Act. So we have to be really careful in how the contract is drafted, because what happened in this case is that the adjudicator has actually held that the pay if certified clause is a conditional payment and allow the contractor to claim for the payment. But unfortunately, this adjudication decision was subsequently set aside by the Court of Appeal. So SIPA. So I will now go through with you fast process for you to get money, to obtain money. So it will start with issuing a payment claim, followed by a payment response by the respondent within 10 working days. After the expiry of 10 working days, the claimant can issue a notice of adjudication to AIAC, and the AIAC will appoint the adjudicator within 10 working days. Upon the appointment of the adjudicator, the claimant will have to serve the adjudication claim within 10 working days, and the respondent will have to serve the adjudication response within 10 working days from the date of receipt the adjudication claim. And then the claimant will have only 5 working days to serve the adjudication reply. And then the adjudicator may call for site visit, meeting, or hearing, but this is optional for the adjudicator. And the adjudicator must compulsory deliver the decision within 45 working days. So the overall process of the SIPA will take around 100 working days. So after the adjudicator deliver the decision, the respondent, if he loses, he have to comply. If he did not comply, the winning party have to enforce this adjudication decision in the High Court as a court judgment, and then we'll have to go through the execution proceeding, like for writ of seizure and sales, winding up, or garnishee proceeding. So this is post adjudication. What happened after I received the adjudication decision in my favor and the losing party pay? So you have to enforce it in the High Court, but the losing party can still file a stay application or a setting aside. But because the objective of SIPA is to facilitate prompt payment, so the second setting aside ground is only very limited, for limited ground only. So these are the grounds for setting aside. There are only 4 grounds for setting aside. The first one is when the adjudication decision was improperly procured through fraud or bribery. There is a denial of natural justice, or the adjudicator has not acted independently or impartially, or the adjudicator had acted in excess of his jurisdiction. So what is breach of natural justice? So breach of natural justice is when the parties is denied a fair opportunity to present the evidence. So for example, in this case, the first case, the adjudicator has actually referred to a document that was not previously disclosed by both parties at all. So what happened in this case is that the adjudicator, he actually conducted a company search on the third-party company without informing the claimant and the respondent, and subsequently rely on the search result without sharing it to the parties. The High Court say that the adjudicator has breached the natural justice, thereby set aside the adjudication award given by this adjudicator. So another example is when the adjudicator refused or failed to comply the parties, and this will constitute as a breach of natural justice, thereby rendering for the arbitration award to be set aside. Or there is a new unilateral communication between the adjudicator and one of the parties without the knowledge of the parties. So this is very sensitive because the adjudicator cannot make unilateral communication with either parties without the other party's knowledge. This will constitute as a breach of natural justice. So what about in excess of jurisdiction? So normally this is when the adjudicator has done something outside of his jurisdiction, like consider deciding a matter that is not raised in the payment claim or payment response, or deciding on a dispute that is not related to construction work. The adjudicator has failed to deliver its adjudication decision within 45 working days, as stipulated under Section 12 of the SIPA. So as an adjudicator, you have to be very mindful of what is stated or the mandatory ruling under the SIPA. Okay, so I will give you an example, and this is the example for the case when the adjudicator has exceeded its jurisdiction, but due to time's constraint, I will skip this. Okay, so like I mentioned just now, an adjudication decision can only be set aside and cannot be appealed. So if you are not satisfied with the adjudication decision, you can actually refer it to arbitration or to court for final determination. So for adjudication decision is only temporarily binding. So what are the others benefit for referring this matter to SIPA. So under Section 29 of SIPA, when the losing party fail to make payment after the adjudication decision ordering so, the winning party can actually apply for suspension by giving a notice of intention to suspend or reduce the work progress to the losing party. So this is an automatic right, despite it's not covered under the contract between the parties. But first, you have to give notice. If not, then you cannot suspend it. Okay. So, and I also under Section 29, the winning party who has executed its right to suspend the project is also entitled to a fair and reasonable extension of time for project completion. If afterward the employer or the main contractor they make payment and the project resume, then the subcontractor will be entitled to a EOT. And further, the subcontractor can also recover all the losses of expenses incurred by the suspension or reduction. And once the payment has been made, they have to resume work within 10 working days. Okay. Another benefit for the statutory adjudication, aside from suspension, is that the subcontractor can get direct payment from principal. So, for example, the subcontractor initiate an adjudication against the main contractor and successfully obtain the adjudication award against the main contractor. But the main contractor has no money to pay. So under Section 30 of SIPA, the subcontractor can write to the principal, the employer or the client to request for payment. And then the principal will give notice to the main contractor to request for proof of payment, to ask the main contractor on whether they have made payment to the subcontractor. And also to state that the direct payment will be made after 10 working days upon service of the notice. So if let's say the main contractor did not provide any proof or did not reply, then the principal will have to make the direct payment to the subcontractor. So this is actually the statutory entitlement to the subcontractor who has won a SIPA matter, despite it's not covered under the contract. But there are conditions is that the subcontractor must prove that there is outstanding payment due by the principal to the main contractor. If not, the principal is not bound to make any payment to the subcontractor. Okay, so does Section 30 allow direct payment to subcontractor if no money is owed by the principal to the main contractor? Like I have governed just now, the principal must owe money to the main contractor, then only the Section 30 will be triggered. Okay, so after we have been listening to the many types of dispute resolution mechanism, so these are actually the side-by-side comparison on the cost, time, finality, confidentiality. So it will depend on parties' preference and also the urgency matter. For my advice, I will always advise my client to go for the SIPA, the statutory adjudication, because it is much more faster than litigation and arbitration. But despite it's just a temporarily binding, but it's still effective because of the slogan of pay first and argue later. So you have to pay first and we can slowly argue it later in the court litigation or arbitration. So there are still other dispute resolution mechanism, for example, expert determination and also dispute board. But usually these two dispute resolution mechanism will only be used when there is governed under the contract. So when there is a contract clause to say that the parties shall refer to expert determination or dispute board. A dispute board is not really common in Malaysia because not every standard firm contract will have this dispute board provision, but it will be very often in the free contract. Okay. To cut time constraint, I conclude that while the nature of dispute is similar across jurisdiction, no matter it's in Malaysia or the resolution process is shaped by the local legal framework like Malaysia, SIPA, and Arbitration Act. It's very of the construction project in Malaysia. Mechanisms such as mediation, negotiation, adjudication, arbitration, and court litigation provide a structured approach to resolve conflict with safeguarding the relationship and also the project guideline. So, whether in Malaysia or in Nepal, I believe that the clear documentation, timely notice, and strict compliance with the contract procedure are very important to avoid and also to manage the dispute. So that's all. So thank you all for your attention, and I hope my sharing is useful for you all. And now I will open for Q&A session. Thank you. Mr. Rajendra, you are mute. We cannot hear you.
Yes, thank you. Thank you. Thank you very much, Eunice. It's very insightful, very informative, and very untiring for your untiring presentation that you made. Very energetic and insightful presentation. So I don't think that there should be some interruption for you. So I allowed you to continue. And it's really interesting. And while you were making your presentation, I think most of all our other audience also compared that Nepali practices side by side with the Malaysian construction practices, and many things you raised. Not taking too much time from my side, I would like to go to some remarks or questions from the audience part. So Dhruva Paudel has 5 questions. So I request him just make your one question, to put your one question only because of the time. Specifically, then I will go to Gokul Burlakoti. He has good comments and a few questions, and some hand were raised there. So we'll have to extend, with your permission, Eunice, 10 to 15 minutes additional. So we may go up to 10:45, not more than that. It's okay?
Okay.
Okay. So Dhruva Paudel, sir, very brief for your remarks.
Thank you very much, Rajan sir. Eunice, outstanding presentation. I liked it very much. That's why I raised a lot of curiosities. Still, I have one more interesting one. Once you go to court and there is provision in the contract that first you go to arbitration and settle everything, and then if the party is not satisfied with the arbitration award, then it is normally the practice to go to the court. Rather than referring to the arbitration, how the court decided that the agreement is void, and how the court decided by making it void and not restricting to the contract.
Okay. Under our Malaysian Arbitration Act, there are actually a few requirements on how it constitutes as an arbitration agreement a valid arbitration agreement in Malaysia. So it must be really important for the arbitration agreement to be very clear, and also and the parties has actually laid out what are the methods that can refer to the arbitration agreement. So basically, these are the basic requirements for a valid arbitration agreement. Aside from that, the parties can also have to be specified, okay, if this matter is to be referred in arbitration, where? So normally, when the parties fail to specify the seat of the arbitration, this is where the problem arises, because the defaulting party will definitely, because they want to protect the matter, to buy more time, you say that no, you should not refer to arbitration because you cannot refer it in Malaysia because this is not stated in the arbitration agreement. And the defaulting party may say you should have referred it to Thailand or to China and so on. They were trying to find every excuse to challenge the arbitration agreement. So this is when the court will come in to decide whether this arbitration will agreement. But for a defective arbitration agreement, I'm sorry, the court will not take into account of this, and this matter has to refer to the litigation. But when there is a valid arbitration agreement, the court cannot intervene if one party refer this matter to court instead of the arbitration. The court must stay this matter in court and let the parties to refer it to arbitration. I hope that I answered to your question, but if you are really interested to know what constitutes a valid arbitration agreement and what is the court attitude, what is the court view in this, we can actually arrange for another session and I can share it to you in details.
Thank you so much, Eunice.
Very much.
Now, Mr. Gokul Burlakoti, sir, it's your turn. Then Sital Subedi, be prepared. Be specific, please. Gokul sir, are you there? His question was actually on proceedings of the construction court, and as you just mentioned, I think we will arrange another presentation at your convenient time. So next we'll focus on construction code, probably the role and the proceedings of construction code. That would be better. So we'll discuss for this with you separately. Sital Subedi, please, sir, go ahead.
Thank you, sir. Thank you for this opportunity. Thank you, Eunice, for such insightful presentation. It was quite interesting and comparable to Nepal also. I have just a little question about the timeline. It was quite good to know that in Malaysia, all the arbitration process should complete within 100 days. But here in Nepal, it has never concluded in that fast timeline. Similarly, another question is, why those less than 4-story building were excluded from SIPA? Is there any specific cause behind this limitation or anything else? Thank you very much.
Thank you, Mr. Shita, for your question. It's a very good question, I would say. Actually, not. Actually, as long as the construction site, the construction project is within Malaysia, even though it is carried out by a foreign contractor, you can still refer this matter to the adjudication. No problem. Can. As long as the project is in Malaysia. Because the objective of the SIPA, the adjudication, is to ease and to solve the non-payment issue, because in Malaysia there are too many abandoned projects. So this is why the government introduced this SIPA, the statutory adjudication, only in 2012, and it considered very recent. Like, for example, we see it in UK or New Zealand, they have actually introduced this back in 1990 something. But in Malaysia, we have only introduced this in 2012. And because there are too many problems, so their main focus is actually on the Malaysia project. Yeah, I hope I answered to your question.
Thank you so much. Thank you for the questions. Any other,
Thank you very much.
if you have any remarks? Ulak sir, you have something to say? No. I think this is it then. No more questions because it was very clear, very insightful, very informative presentation. And
Dr. Sir,
Azur, please.
I identify my answer. Yeah, thank you so much.
A construction code part that will arrange another presentation focusing on all the proceedings and the practices of construction code in Malaysia. That why we agreed and concluded for this matter, Gokul sir. So we will will again request Eunice for our generic support for us. So then your question did not answer in that respect.
Thank you. Anyway, thank you so much, Eunice, for your wonderful presentation. Thank you so much.
Thank you, sir.
You're
So
welcome.
it's a CIDB, it's Construction Industry Development Board is in Nepal also. We also do have that under Ministry of Physical Infrastructure and Transport. And it is created by Construction Business Act. In Nepal, there is an act, but it is not that much active and effective as in Malaysia. This is one part. And one that I would like to just be a little bit clear about the international arbitration, because you mentioned that there is no foreign party participate in Malaysian construction. Yes, is it like that, or it is restricted to?
It's restrictive. There are some requirements that you have to satisfy.
So what makes that domestic arbitration and international arbitration in Malaysia? So please.
Okay. For domestic arbitration is when it involves the project is in Malaysia and it involves both parties in Malaysia. But for international arbitrations, otherwise, the project can be in Malaysia. The contractor might be the contractor from China, from Thailand, from Indonesia, from Nepal, and this is we call international arbitration. Yeah.
Thank you for this clarification. So, and the other parts of this, I want to substantiate your presentation that Nepal also do have adjudication. It practiced adjudication before arbitration. And in 2006, when Public Procurement Act was enforced, so there was a provision for this, and within 30 days, the adjudication has to be resolved. The decision has to be awarded.
30.
But yeah, it was good, but we could not practice as the law envisages, as per the law. So after 10 years, it is repealed. So this is somehow a different thing than how the other globe is going, moving. Because you just mentioned about your UK Adjudication Act also practice also, and Malaysia and in other part of the globe that it is being effective and it has been practiced with a good result. And that was not the case in Nepal. So we need to have further study on this also. We have not made that much in-depth study why this could not work in Nepal. So this is the scenario in Nepal. And most of the large projects are funded by development partners. So, and we use FIDIC document for the international and foreign contracts. And there we do have this DB dispute provision in the contract. But again, they are not that much active, enforced as in the contract. So dispute resolution mechanism is also somewhere in this type of confusion, whether this thing has been effective or not, something like that. So arbitration is there, and definitely the payment issue is associated with all arbitral decisions and the enforcement of the contract. And while comparing with that, the act you mentioned related to payment, and pay now and argue later, this type of thing which we need to more highlight in the context of Nepal, because these days we have many sick projects. Most of the projects are sick. We call it sick, because they are not completed, and the contractor are saying that they are not getting payment on time. So payment issue is there. So this type of thing is here that we are facing. Therefore, your presentation was more relevant to compare with our current problems, difficulties, as well as with the practices. So I think with this remarks, Eunice, again, from all our Nepalese participant audience, on behalf of them, I would like to thank you very much for your very generic and very nice, very insightful presentation. And if your time permits, we'll request you for your another presentation on this construction code proceedings part. So would you like to say anything?
Thank you, Mr. Rajendra, for sharing the overview in Nepal and also the current problems that are facing by Nepal. I think we can relate, because these are very common problems that arise in Malaysia as well. And after hearing from Mr. Rajendra, I would really love to know more about the Nepal construction industry, and also the dispute resolution mechanism. And I also hope that I can share more to all of you about our Malaysian construction industry, construction court in details. So I really hope that I can have the opportunity to see you all again next time. Thank you so much.
Thank you. With all this, have a good day for you all. And I would like to conclude this presentation here. Thank you, our NEPCA staff, for making this platform available. Thank you, Eunice. Thank you all.
Thank you.
Have a good day.
Have a good day, everyone. Thank you.